Welcome everyone, welcome here to another episode, and this is Pointers TV, and it's all about politics. So today we're gonna be taking a look at the Kenyan politics and some of the affidavits that have been submitted to the Supreme Court, and we see how the Supreme Court procedures will be going through. We're also gonna be talking a lot more on the Supreme Court issues. And from what we are seeing, a lot of issues have been raised so far in terms of evidence, whereby we are seeing that one of the IBC officials have managed to confess and said that he faked and manipulated presidential results in favor of his boss, or rather employer. And in this affidavit, the former Kenyan journalist and anti-graft advocate John Githongo has brought to light new evidence on the presidential results that were announced last week by the IBC chairperson Wafula Chebukati. Mr. Githongo submitted an affidavit to the Supreme Court of Kenya, introducing a whistleblower who was decided to hide his identity as a safety measure. The whistleblower claims to be among 56 hired IT specialists by presidential candidates who took part in changing the Form 34As. Mr. Githongo says the man was part of the supervising team while other 46 IT members changed the data by manipulating votes from one candidate to another. While the other 46 people were accessing, entering, and manipulating the entries, he was one of the supervisors. The task was to collect from Form 34As from Kim's kit and send them to their server, or rather platform, which he called Uchaguzi Tallying, and used to the so-called aka Uchaguzi 2022, the man said. And after receiving the data, they would edit Form 34As in accordance with the instructions given and upload edited Form 34As given and upload edited Form 34As to the IBC portal. According to the whistleblower, there were 10 computer specialists and 46 other recruited members who worked at the Bomas while subtracting numbers from one presidential candidate and adding to another as part of scheme to make the employer to win, or rather to make the employer the winner. John Githongo's affidavit noted that he received the whistleblower's details and recorded his statement on a camera to be availed in court privately to protect him and his family. The team was and his family, I think that is for safety, you all know. And the team was indoctrinated on the phrase, "the freedom is coming," and that they needed to be freed from dynasties, in this case, the petitioner. Read the affidavit on the other side. A lawyer who sought anonymity argued that the affidavit submitted by Mr. Githongo will not be inadmissible in court, as it was just hearsay, and the whistleblower has not sought witness protection from the Supreme Court. Okay. So that means that that deposition is not admissible evidence in court. It is hearsay evidence. If they are serious about that evidence, they should pray to court for witness protection under the Witness Protection Act. So far so good, that's how we are getting it. So these and much more details, we shall be following the proceedings in the Supreme Courts, and we're also going to be updating you guys. For this and much more information, make sure you do hit the subscription box and keep yourself locked. Make sure you don't tap the dial. Thank you so much. Till we meet again for our next the other episode. Thank you.